Well, let me tell you a little something here on this one. This right here, it says it's a copy. And what this is, it's a letter. It's a filing by the law firm of Anderson, Julian Hall. This clearly shows how they lied at oral argument on June 5th of 2013. This is what Lynn Luker allowed them to get away with, because this is what I did, and I won, and I was able to accomplish without Mr. Lynn Luker / legislator, who is a workers' comp attorney who takes clients. But anyway, what this is, it's a letter, and it's a notice of compliance with the Commission's February 6, 2009 order on motion to compel. But, they're stating that my filings amount to nothing. They can't understand them. But obviously, they filed to them. Okay, here it is. Notice of compliance. Come now, defendants, by and through their undersigned counsel of record, and give notice that on this date, defendants herewith provided claimant with defendant's proposal Rule 10 hearing exhibits, which contained every medical record in their possession or control in connection with this claim. Now, what they did is they got rid of a bunch of them before they did send me the records. Regarding the Safe Corporation records requested by claimant, see letter dated January 17, 2009, page 3 of 3, and letter dated January 12, 2009. Defendants understand that claimant has extensive pre-accident medical records, including records in connection with a work-related arm injury for which claimant settled a workers' compensation claim with Oregon Serenity Safe Corporation just prior to the accident. Now, the accident happened. The accident happened in 2005. But did they settle? Yeah, they paid me some money, but I was working too. So, to me, they're the ones that came to me and wanted to bring it to an end. So that's what happened there. That is the subject of this claim. Defendants also understand that the Oregon industrial accident involved the same right forearm or elbow. It was the elbow. Not the arm, the elbow. Which I can't use the elbow because I can't use my fingers or my hand properly. That is the subject of this claim. Although these records are clearly relevant to claimant's current claim and may in fact aid his current medical provider in his current treatment regime. Defendants no longer have copies of Safe Corporation records. Claimant apparently contacted Safe Corporation. Well, heck yeah. And therefore, Safe Corporation contacted the state insurance fund. Oh yeah. And requested the return of all copies of the records in connection with claimant's Oregon workers' compensation claim. Pursuant to Safe Corporation's request, State Insurance Fund returned all copies of records and all safe records scanned or otherwise stored in any capacity by or on behalf of the State Insurance Fund have been destroyed. A copy of the State Insurance Fund's letter to Safe Corporation dated January 30, 2009 is attached here to Exhibit A. Defendants assert that the Commission's order on motion to compel clearly applies to Safe Corporation's records, as well as any other medical and psychological treatment records, and thus any objection to defendants' use or these records is now moot. Claimant represented on numerous occasions to defendants that he has copies of Safe Corporation's records, and therefore he will be required to provide copies of the same to defendants as requested in defendant's discovery request. Now, what that's all about is that I had Safe Corporation records, because when I contacted Safe Corporation, they mailed me the 2 copies of the letters that they used to receive those documents. Now, what they used to receive those two documents. Now, what they used was Dr. Hansen's medical release that I signed for him. And I received the letter that they used along with that medical release form. Those are the two documents that I had in my possession. So when they say that I had records, well, I did have records. The ones that Safe Corporation sent to me at my request to find out exactly what they had done and how they received those records. And when I found out that they had received them fraudulently, well, you know what Safe Corporation did. They demanded the return of all those documents. So if those records are deemed moot, M-O-O-T, as Miss Rachel O'Barr always tries to correct me on, then Mr. Lynn Luker, why did you allow then things to be put into the records at my hearing then? Because aren't those the ones that were scammed into my records at a hearing? The ones that were supposed to be deemed mute, the ones that they said that they, in a writing, in a file, that was a copy file of it, that they had returned all these records and they had nothing in their possession? That was a lie. Because isn't it a fact that that's what they talk about when they say that those records, the commission deemed they were, well then, how come you didn't send off for more of them? Because supposedly you don't have them in your possession anymore. So you see, fraud, because you did receive those fraudulently. And fraud, a deceit, to keep one. You see, when you were telling the Industrial Commission for 3 months that you couldn't receive these documents until after I signed them, well, clearly, because this document here that I just read to you, you see right here, well, that documents were done in 2009. Because you see, I have yet to sign any medical release forms for them to receive any records. Because I was denied by the Industrial Commission to make them come forward. Because they're making my motion look as something different to the Supreme Court or whoever they're doing it to. Or what, because I was denied, I don't know. I just don't know what's even going before the Supreme Court anymore. Because if you look at my one where an injured worker fighting corruption in Idaho, my other YouTube page clearly shows them all. But this one right here is going to be specific for Mr. Lynn Luker / legislator. You see, because he knew about this. Now, Mr. Lynn Luker, why did you allow them to sneak those in there? Because that was the file that you all talked about at the very beginning of the hearing as you read the transcript. You see, and how you object to some of them, and how some of the things were, so obviously you already knew what was in them. I didn't know what was in them. I wasn't allowed to know what was in them. Now was I, Mr. Luker? Because I wouldn't have went for it. Because again, you weren't there to help me. You were there to help to protect the state insurance fund of the fraud they committed. And the ultimate abuse of Mr. Donahue, the referee of the commission, that was assigned to my case, which clearly should have stepped aside. And again, Mr. Lynn Luker, Mr. Lynn Luker, you're a quitter. You're a scammer. You take advantage of injured workers because clearly this was a major argument of mine before I hired you. And this is what I hired you for. It was right here for this complaint that I filed of the fraud. And this is part of that fraud. And then you do nothing about it? You knew nothing? Oh, wait till I produce your letter that you filed in February, Mr. Lynn Luker. How you took everything that I had fought for 2 years before I hired your punk ass, and you turn around and do this to me? You're nothing. You're a scammer. You use your office for profit, man. And Lynn Luker, I'm not going to stand by and allow you to do this to me or any other person if I can. Because you're a quitter, Mr. Luker. I don't know what they've done over there at the Idaho Supreme Court, but Mr. Steve Kenyon in that phone call, tape phone call, he said that he was going to make sure that that was fixed, because I made sure, because I asked him a couple times about it if he understood what I was saying to the United States Supreme Court. Because if the Supreme Court, as you all, as you know, well, you're not supposed to be involved in my case from what Steve Kenyon says, also in that conversation, but you know, I have a letter that I sent to the commission to also have your lien forwarded to the Supreme Court in late July. Now, how could that have been? And they've already, and then they send me a, you know, yeah, you guys are scamming over there, man. No wonder, you know, you guys put something together to take it, you know, to put into place for workers' comp, you know, the judicial or whatever, you know, committee, you know, and you guys are the ones that make the ultimate decisions. Well, that's because, and that's why a lot of people are being denied now, because, you know, what can they do? You know, I'm doing it because I don't have a choice, man. You know, I got my grandkids tonight. You know, I got them down, you know, and grandma's at work. Grandpa's out here again, trying to do his work to try to move forward so I can spend better quality time with my grandkids. But Mr. Lynn Luker, you're a reason for this also. And what about that thing I have before the Idaho State Bar on you, Mr. Lynn Luker? Did you write that letter to me that, Mr. Lynn Luker, would you like me to show you the letter? Oh, that will be coming. That will be within the next couple of them, because I notice on all my videos that I posted, you are the one that they're looking at the most. So that's why I'm going to go ahead and make this one here about you, Mr. Luker. This YouTube channel will be about you and about how you take advantage of injured workers and use your seat for financial gain.